Asylum status is a form of humanitarian protection offered by the United States. Raju Law, one of the top immigration law firms in the USA, is your trustful address for any assistance and advice regarding immigration to America. To know more, dial the number shown on your screen.
Hello and welcome back everyone to our another episode of the live session hosted by attorney Raju Mahajan and Associates. For today, I am your host Isabella Rosario and I have none other than a very special guest who is our principal attorney and our founding attorney as well, Mr. Raju Mahajan. Mr. Mahajan, it is an honor to have you here with us today.
Thank you very much, Isabella. I thank everybody who are watching our show right now and will watch our show in future in our other social media.
Yes, thank you everybody who has tuned in to watch our show. Today we have a very interesting topic that has been prepared. Our topic for today's discussion is what is sponsor liability under I-864 Affidavit of Support. Mr. Mahajan, what are your thoughts on the topic?
Thank you very much. Can I see the screen? Perfect. Okay, thank you. So, many of us, especially U.S. citizens and permanent resident, we want to help others when they try to immigrate to America, and especially in family-based categories and few other categories, when any other person try to immigrate to America, they need sponsorship. They need somebody in America to fill up the form I-864. Its name is Affidavit of Support, to make sure that they can easily come to America. However, this sponsorship, while it is very generous, it is very good for immigrants. However, the person who is sponsoring this, who is signing this affidavit of support form, who are sponsoring this immigrant, he or she is taking a huge responsibility, huge burden on them. It is always good. It is always good to help others, but you must know what responsibility you are taking when you're, signing the form I-864 for others. So today we are going to discuss what responsibility, what liability you are going to take when you sponsor others in family immigration and other kind of situation where you submit I-864. Next slide, please. So first of all, it is a contract. Many U.S. Forms, many forms that we submit to USCIS, these are not a contract. These are basically a immigration application or petition. However, Form I-864, this is a contract, and the contract is between the sponsor and U.S. government. So many people, they do not understand this, this dynamic of being signing a part of the contract. So, contract is a separate law. This is not a part of immigration law. The contract law depends on state. Every state has their own contract law. For example, New York, Texas, California has their own contract law. So if you live in New York and you sign the form I-864 on behalf of immigrant, not only you are going to follow all the immigration consequence of this I-864, at the same time, you are also you must abide by all the contract laws of that state. So that's why please remember that this is a contract between you and the US government. So I'm going to read it. In the contract known as Form I-864, the sponsor makes a commitment to the US government to support the intended immigrant if he or she is unable to do so now or in the future. So this is the sentence. The bottom line is this is a contract between the sponsor and US government. Next slide, please. All right. So what responsibilities of a sponsor? So what responsibility and liability you're going to take over when you sign the form I-864? The sponsor, including the primary and secondary sponsors and the US government and parties to this agreement, as I said before, by agreeing to the terms of the contract, the sponsor guarantees that they will make enough money to support the immigrant. You make enough money to support the immigrant. The sponsor clearly states that his or her income is at least or above 120% of the poverty level by calculating their household size, including the intending immigrants. So, America publishes their poverty guideline every year. Right now, it is probably for a single person, 13,500 something kind of dollar. So, if you are a single person and if you are going to sponsor another single person, then your household size would be 2. And for 2 person, the poverty guideline would be probably 16,000 or something. You can double check that in USCIS website. The name of the form that indicates the poverty guideline is called I-864P, P for PAM. So if you do not know the poverty guideline for 2-person, 3-person, 4-person, you can go to I-864P form in USCIS website and see what is the poverty guideline. So you are agreeing to make more than 120%, 125% of the poverty guideline, depending on the number of your household, including the intending immigrants. So you must understand these dynamics. The next one is the joint sponsor specifically promises that if the sponsored immigrant cannot make an income equal to or greater than 125% of the federal poverty level, she or he will support this immigrant. So this is a big deal. What it means is when you are sponsoring an immigrant to America, if the immigrant who just came to America, if he or she cannot make 125% or more of the poverty guideline, then you are going to support that person, not the US government. You are going to support that person. In most cases, US government do not enforce this clause. However, if they want, they can do it. That is the point of discussion for today's discussion. Next slide, please. All right, so the sponsor is obligated to reimburse the organization that supplied any means-tested public benefit that the immigrant received. So the meaning of this sentence is, a lot of time, when people live in America because of many, poverty, because of, sudden changes in their employment, or having pregnancy or having baby, there's a lot of public benefit offered by American government. In general, it is called means-tested public benefit, meaning it depends on the demand. A lot of time, a lot of state benefits are also mingled with public benefit. So federal benefits. So let's say the state of New York, they are offering some, week program, like a SNAP program for, food stamp and other kind of benefits. Let's say 70% of the money come from state government and 30% of the money come from federal government. So even it was offered by state government, if there's any money from the federal government within any program, then you are subject to liable in those kind of benefits. Meaning, if the immigrant, if take any benefit from government, the agency who provided those benefits, they can sue you, or they can ask you to pay those money on behalf of the immigrants. In most cases, in general, US government do not enforce this clause, but if they want, they can do it. That's I'm going to tell you. All right, the last responsibility is a sponsor who is not a US citizen should inform the USCIS whenever he changes their addresses. A lot of time, especially when we have green card, we stop reporting our change of address to USCIS. That is not correct. The official rule is until you become US citizen, you must report USCIS about change of your address within 15 days of any changes, especially if you submit a form I-864 on behalf of other person, you must report your change of address to USCIS until you become US citizen. So those are the responsibilities. If you need more information about this, you can always reach out to us. I or anybody from our firm, we can help you. Next slide, please. All right, so duration of responsibilities. So this is a lot of people, they don't know this duration. A lot of the durations are very strict and very counterintuitive. So as soon as the sponsored immigrant has their green card, the sponsor is obligated to provide financial support. Only one of the following subsequent 5 terminating events can bring the obligation to an end. Meaning, as soon as the intending immigrant become a green card holder, then the obligation starts, and until one of these 5 things happens, you have to support these intended immigrants. Number 1, the sponsored immigrant becomes a US citizen. So meaning when the intended immigrant they become US citizen, your obligation ends, which is a good thing. However, in most cases, it takes 5 years. In some cases, it takes 3 years. In very few cases, it takes 6 months. In general, it takes 5 years to become a US citizen. So you are obligated to support that person for 5 years. Number two, the sponsored immigrant has worked and can receive credit for all 40 quarters of coverage under the Social Security Act. I'm not going to go that detail into this thing, the Social Security Act, because this is kind of complex, and in most cases, most of the people they don't qualify for this. So just for the information purpose, I kept it here. If you need more information about that, I can talk, one-to-one and can describe. Number three is the sponsored immigrant no longer has lawful permanent resident status and has departed the United States. Meaning the immigrant whom you sponsored, he or she lost the green card and already left America. So once they lost the green card, your responsibility ends. Next slide, please. Number four, the sponsored immigrant is subject to removal, but applies for and obtains in removing proceeding a new grant of adjustment of status based on a new affidavit of support if one is required. Meaning, he or she came to America with your sponsorship, and later, because of some reason, his sponsorship has been changed because of some reason. I'm not going that detail into removal proceeding and other thing. So as soon as your sponsorship ends and some other sponsorship starts, your responsibility ends. Number five is the sponsored immigrant dies. When the sponsored immigrant dies, your responsibility also ends. So these are very strict. In most cases, number one applies, which is when the sponsored immigrant become a citizen, then your sponsorship ends. Typically, it is 5 years. Next slide, please. So here I'm going to tell you some situations, where you have to be careful about this I-864, because this is a contract between you and the US government. So every sponsor should keep in mind the following matters before signing the contract. When somebody agrees to financially sponsor a fiancé or spouse, they should keep in mind that the sponsorship obligation does not end with a divorce. This is very tricky. Even though you are divorced, until and unless your sponsored spouse become US citizen, you're obligated to support that person. And divorce law, family law is also another state law. So let's say your spouse lives in Texas. So all the rules and regulations of Texas family law will be applicable, including this sponsorship. Meaning, in general, if your spouse does not have enough money, you have to pay alimony, child support, property division, including all these things. This 864 will create another liability, and you have to pay additional money. The sponsor will still be liable to his or her ex-spouse financially even after the divorce. This is situation number one. Number two, although the sponsor is not liable for the immigrant's personal debt and bills, he or she is usually responsible for making sure the sponsored immigrant have enough financial means to meet the US poverty line. So the short thing about this thing is, we all, excuse me, we all have credit card debt, home loan, car loan, utility bill like electric bill, gas bill, sewerage kind of bill. You are not personally liable for all those bills, but you have to make sure that this person meets the US poverty guideline. You have to make sure that part. If the immigrant sues the sponsor for financial support, the sponsor could be held guilty. As a matter of fact, the immigrant could decide to quit a job and sue the sponsor for support. Even the sponsor is responsible for the sponsored immigrant's legal fees and cost to enforce the I-864. Not only you will be liable for the support, you will also be liable for the legal fees to enforce this clause. So it creates a huge liability. That's why I made this. I'm talking about this thing today. A lot of people, they don't know what they're signing for. Yeah, next slide, please. If the immigrant receives benefit from certain means-tested assistance program and the sponsor refuses to voluntarily refund the benefit, the US government may sue the sponsor to collect benefit program cost. Meaning, if the immigrant receives any kind of fund, and if the US government wants to get that money from you, the sponsor, if you do not voluntarily pay those things, US government can sue you. Again, US government in most cases do not enforce this clause, but they can if they want to. Next point is, if the sponsor is not a US citizen and fails to inform the USCIS about his her address change, the USCIS may fine the sponsor in order to stop sponsors from evading their financial obligations to the immigrant. Again, if you do not, report the change of your address, U.S. government may fine you. The last point that I'm going to discuss today is, if the sponsor is obliged to file for bankruptcy because of financial insolvency, he or she cannot discharge their financial sponsorship duty. Therefore, bankruptcy may not be able to release him or her from this liability. This is another big deal. Meaning, a lot of time when somebody has business loss or some other kind of situation, you have a lot of liability, you file bankruptcy, to get rid of all the liabilities. You may get rid of many other liabilities, but you will not get rid of this I-864 liabilities. So it will even survive after your bankruptcy. So this is a big deal. Next slide, please. So that was our discussion about I-864 liability and responsibility. I hope, I'm not asking you to not sponsor other people. Definitely you will sponsor other people. However, you must take informed decision what responsibility and liability you are going to take. Thank you.
Thank you, Mr. Mahajan, for that informative piece of presentation. I'm sure all of us, we know a lot more now about the sponsor's liability under the I-864 Affidavit of Support. In the meantime, we have already had a question that has been submitted to us from one of the audience members named Fatima Tasmia. Ms. Tasmia says, "Good morning. Is the premium processing for change of status from F2 to F1 currently active? What is the estimated total cost of premium processing and others fee for the change of status from F2 to F1?" Mr. Mahajan, your thoughts, please.
Yes, it is currently active. It is currently active, and the fee is $1,750, including you have to pay attorney fee and other kind of fees. But the premium processing fee is $1,750.
I hope that answers your question. Now, audience members, we have had some questions that have been submitted to our emails, so we will just be discussing the answers to those questions today. One of the questions has been sent in from Mr. Nasir Uddin, and he asks, how long can it take to get a social security number after an asylum petition?
So once you submit your asylum petition, usually after 5 months, you are eligible to apply for a work permit. Once you apply for a work permit, usually it takes 1 month or 2 months. Sometimes it may take longer to get your work authorization approved. As soon as your work authorization is approved, usually USCIS will send a social security card, including a number, to you. However, sometimes they either forget it or they do not do it because of some reason. In that case, as soon as you have your work authorization card with you, you can go to your nearby Social Security Administration office and apply for a Social Security card. You can do it online too. In most cases, online would be faster. But if you are not familiar with the online system, you can go to your Social Security Administration office. And in general, no matter where you live, there's a Social Security Administration office within 5 to 10 miles of your home. So you can easily find it, go to your Social Security Administration office and apply for Social Security card. Short answer to your question, usually you may get it within 6 or 7 months of applying for asylum.
Mr. Nasiruddin also asks, upon getting a social security number from an asylum petition, are there any categories of jobs which are only permitted for the asylee applicant, or can he do all types of jobs in the US? The third question that has been submitted from Mr. Nasiruddin is, can the client get a driving license in the USA once he gets the social security number?
Yes, the answer to the previous question is you can get any job that you are qualified for. It depends on your education background, your skill, and other thing. But there is no restriction on a job that you can apply under asylum application. You are eligible for any kind of job that you are eligible. Number 2 is, yes, you can apply for driving license definitely after getting social security number. Even as soon as you apply your asylum application, as soon as your asylum application, you get your receipt notice, you can go to your local DMV. So there's the important information here. DMV is also part of a state government. Every state has their own law regarding whom they're going to issue, um, driving license. I know New York, they issue driving license to pretty much everybody. So you even don't need to wait for asylum application to get driving license. So I would request you to go check your local DMV. What are their requirements? If they say you must have a social security number, then you have to wait to get social security number to apply for driving license. However, if they say, no, you do not need a social security number, if you have like a valid stay here in America, you can apply for it, then go ahead, apply for it. It depends on your local DMV.
I hope that answers your queries, Mr. Uddin. We have received another question from Mr. Akbar Hussain, and he asks, once the court calls the client for an asylum hearing, then can the attorney also participate in the hearing with the client together? And can the attorney explain the client's case history to the court on behalf of the client? The second question is, can the client stop his asylum case file in any stage during his asylum status pending?
Yes, of course, lawyers and attorneys, they can go with you, go with the applicant to the court. That is the job of the attorney. They go to court, they argue on behalf of their clients, and they can, explain, they can tell. So that the entire court procedure, I would say 90% of the activity is between the attorney and the judge. Usually they will ask question and you just answer your question. That's it. 90% of the work will be done by the attorneys. So they will go with the client, they will argue. If the opponent attorneys ask any question, definitely client will answer those questions, but attorneys will also explain it. They can, object. There's a whole activity. So short answer to the question, yes, attorney will go with you and they will take a huge part of this process. Second, what is the second part of the question?
Mr. Mahajan, the second question was, can the client stop his asylum case file in any stage during his status pending?
Yes, you can withdraw your case anytime as you like. There is no time time barrier. You can withdraw anytime you like.
I hope that answers your question. We have received another question from Ms. Fatima Tuzjoha, and she asks, if I apply for an EB3 visa from Bangladesh, and once I get the LC approval, or once my employer in the US applies for the I-140 petition, that time if I apply for a B1, B2 visa, then does my B1, B2 visa make any conflict with my EB3 application for the stages of I-140 or DS-260?
Yes, it does. Especially after you submit your I-140, either you or your employer, basically your employer is going to sign. When you submit your I-140, and after that, if you try to submit DS-260 for B1, B2 visa, it creates a conflict. However, just because it creates a conflict doesn't mean that embassy will not issue your B1, B2 visa, because embassy knows that even after I-140 approval, it may take a long time, sometimes 2 years, 3 years to just get your visa interview in embassy, and then you'll be able to immigrate to America. Since there's a lot of waiting period, a lot of time embassy also issues B1, B2 visa that you can come to America and visit your friends and family or do other job. So bottom line, the short answer to your question, even though it creates a conflict, you are still eligible to apply for B1, B2, and sometime you may get it.
The second question that was sent in by Ms. Fatima Tuzjoha was, my second question is, during my EB3 filing in any stage firm to DS-260, if my husband applies for an E2 visa from Bangladesh or from the US, then does his E2 application make any conflict with my EB3 application?
Again, it may create a little conflict because one is the immigrant visa application, another is a non-immigrant visa application. But American government encourages E2 visa application because it creates a job, creates job in America. It's good for American economy. So again, even though it creates a little conflict, your husband can get E2 visa.
I hope that answers your queries, Ms. Fatima Tuzjoha. Our last question from our archives is sent from Mr. Shagur Khan. And Mr. Khan asks, are there any particular states in the US where the asylum case petition can be ended in a faster way? Also, are there any particular states in the US where asylum case success rates are higher than other states?
So I face this question all the time. Short answer to your question: no. There is no state where it goes faster than other state. There is no state where um, the approval rate is higher, because immigration depends on federal law, and federal law is equally applicable to all states, regardless of where your case is pending. However, there are some situations like, if you apply in New York, there's already huge caseload. So a lot of time, it takes a little longer time in New York to get it, processed, get it approved. The processing time is longer. If I compare that with, like, let's say North Dakota, there's like a very few asylum applications. That's why probably the caseload is very low. However, in New York, probably there is a more immigration judge than in North Dakota, because federal governments appoint judges based on demand. In New York, there's a huge demand for asylum cases, immigration judges. So federal government appoints a lot of judges in New York. On the other hand, since there's a less pressure in North Dakota, there's less number of judges. Similarly, U.S. attorneys who represent U.S. government in asylum process, there's a more U.S. attorneys in New York than North Dakota. So there is both, good and bad side of all states. California, New York, Texas, they're one of the top state for asylum cases, because a lot of immigrants live there. At the same time, there's a very few cases in North Dakota, South Dakota, Idaho, Wyoming, Montana kind of states. However, there's also less pressure, less judge, less activity, less everything. So bottom line, it's kind of the same. It doesn't matter where you're filing. It doesn't matter when you're filing. It is pretty much the same.
I hope that answers your queries, Mr. Khan. In the meantime, we have received a comment from one of our spectators. Mr. Anisuzzaman Anis says, very informative. Thank you so much, Mr. Anis, for your compliment. In the meantime, Mr. Mahajan, I wanted to ask you one final question for today. Are there any updates we should be looking forward to?
Yes, there is the immigration update. Let me find. There's a very tiny update. There's not a lot of update today. So many of you already know that U.S. government issues TPS, temporary protective status, for many countries. So temporary protected status designation for El Salvador, Honduras, Nepal, and Nicaragua reinstated and extended for another 18 months. So those who are from these countries, I'm reading it again: El Salvador, Honduras, Nepal, and Nicaragua. If you're under TPS, your TPS has been extended for another 18 months. That was our update today.
Thank you so much, Mr. Mahajan, for that informative update. Everybody, audience members, we are now at the end of our live session for today. Thank you, Mr. Mahajan, for being here with us and for your time. Audience members, we will see you next week at the same time with more informative topics of discussion. Thank you so much for tuning in. We will catch you next week. Goodbye.
Asylum status is a form of humanitarian protection offered by the United States. Raju Law, one of the top immigration law firms in the USA, is your trustful address for any assistance and advice regarding immigration to America. To know more, dial the number shown on your screen.